What's up, everybody? We have an interesting motion that has been filed, or I should say, a response that has been filed by Kohberger's defense team regarding the state and their motion to reconsider the court's decision to stay the case for 37 days for speedy trial purposes only. And it's an interesting response here. It's not, I wouldn't say it goes to the level of threatening, but it definitely warns the state against doing things that potentially violate the citizens of their state that they represent, potentially violating their constitutional rights and their statutory rights, especially one as important as that of a speedy trial. The state is in such control of a case and the timing and when and how and why things happen that this warning is one that I actually think would be good for a lot of prosecuting offices and attorneys to think about as they go through a case and as they balance what pieces of evidence they want to fight, what arguments they want to make, what delays they are going to cause and create inevitably by making these arguments and trying to block certain things or pieces of evidence because they also have a right to a fair trial. And we're going to be going into that right a lot here in the month of August and September when we go through our podcast series about how media is playing a big role in the courtroom and what that's going to look like in the future. We're going to talk about the defendant's rights, but also the state's rights, because they do, in fact, have rights throughout this process. So we're going to read this response together. We're going to talk about it. Hit your questions in the comments. And I've already had a lot of questions come through Twitter and Instagram about this. So that is why we're going to do this video here. The website where I get these, the Idaho website where these motions are available publicly has been down over the last couple of days, at least for me. So we are going to grab them from Sleuthy Goosey's Twitter page, our friend Sleuthy Goosey, who posts a ton of stuff about this case and specifically the documents a lot. That's where I saw it. It's one of the people tagged me in this post. When I went to go grab the document, couldn't find it. So we are just going to audible here and use her page. Hit that like button if you haven't already. If you're still interested in the Kohberger content, that's the way you can let me know. And also subscribing to our page if you haven't already. So it's a little hard for you to read, but I will read it for you every word so we don't have to miss anything. This is, again, the response to the state's motion to reconsider the order staying time for speedy trial. The judge granted that, allowed for 37 days, extended the speedy trial period, partial-ish waiver and agreement by the defense that they're not going to claim, day 6, month, and 1 that their speedy trial rights were violated. Everybody's in agreement on that side, at least because it is the defendant's right to a speedy trial. So we're not going to have that issue, at least as agreed to in that motion. Doesn't mean they can't come up and try to argue it later. And I think that's what the state's worried about, is the defense later is going to say, oh, gotcha. But let's hear how the defense responds to that state motion to reconsider. Comes now Brian Kohberger, Brian through their attorney, Jay Logston, Chief Deputy Litigation, and hereby submits the following response to the state's motion to reconsider the order staying time for speedy trial. The state's motion is concerned only with Mr. Kohberger's statutory right to a speedy trial, though it never makes that plain. I felt like it was plain enough. To be clear, there is no way to read a partial waiver of a constitutional right as a full waiver. I disagree with that. I disagree that a partial waiver cannot actually be a full waiver because somebody thought it was a partial waiver, but it was actually a full waiver. A legitimate partial waiver by definition, of course, is not a full waiver, but I have absolutely seen cases where defendants thought it was a partial waiver, but it actually turned out to be, when you argued about it later, a full waiver of speedy trial. It sucks. It feels unfair, but it does happen. Other jurisdictions use partial waivers of speedy trial. That is true. The state cites to State v. Lundquist, wherein the court explicitly states that there is nothing wrong with a partial waiver for purposes of constitutional rights. Again, they're saying it here, and it can be other constitutional rights as well. And you can partially waive them here and partially waive them there, like your Fifth Amendment right. You can partially waive it for an interview, but that doesn't mean you always have to talk when you're talked to or when you're spoken to. You don't have to take the stand if you've been interviewed in the past, even if you've waived your Fifth Amendment right. So that can be a partial waiver. We get that. You can invoke it later. Speedy trial is a little different than the Fifth Amendment, but they're both constitutional rights. And I do agree with the defense. I think it is appropriate what they did with the judge because the judge allowed it. It solved a problem that was a fundamental fairness and justice problem for the defense to get these grand jury documents. They had that problem. The judge decided to allow it, but did not make it a delay attributable to the defense and therefore allowed it to be a partial waiver. But I mean, just me saying that, you can understand how arguments could later be made. Technically, that is a delay attributable to the defense, which we dove into that argument a lot when we talked through the motion for the stay and then the motion for reconsideration. So if you want the deep dive on that, check out those videos on our page. The state demands that the trial date remain where it is without a waiver of speedy trial. The state is free to take this position, but it is one with consequences. And this is where the warning comes in that we're talking about. The defense is warning the state here. It has long been established that a state may not impose a penalty upon those who exercise a right guaranteed by the Constitution. Constitutional rights would be of little value if they could be indirectly denied or manipulated out of existence. The state brought this prosecution and did so on its own timetable. By the way, Sleuthy did this highlighting, I believe. Now that timetable must abide by Mr. Kohberger's constitutional rights. The state cannot cry foul when its decisions post-arrest make an October trial date untenable. So what is he saying here? State, you chose when to charge this. You chose the timetable. You knew there was a 6-month speedy trial window post-indictment here. So none of this is a surprise to you. And if you weren't ready, too bad. You can't file these charges knowing the defendant's constitutional rights and then do things to violate those constitutional rights. That's the exact opposite of how it is supposed to work and how it will work in the interest of justice. Mr. Kohberger has a right to a fair trial, to a defense, and to due process. And that line right there to me is one of the most important lines in this entire response. The fact that he has a right to not just a trial in 6 months, right? That's important. Speedy trial is not like just forget everything else. Let's make sure we get a jury and try this case within 6 months. That's not what it means. It means he's going to have a fair trial, a competent defense, and due process within that 6 months. So what does that include? That means the discovery he's entitled to, the witnesses he's entitled to, the experts he's entitled to, the defense he's entitled to, the alibi potentially he's entitled to, which we know he didn't end up giving, but he was entitled to give one if he wanted to, if he had one. These are all rights of due process and of a fair trial and of a competent defense. So you can't, as the state, reject or block any of these rights. You can't make it an unfair trial. You can't stop him from having a competent defense, and you can't violate his due process rights just to get the case to go in 6 months. That's not how it works. These constitutional rights all work together. He is not required to give up his right to a speedy trial in this matter because the state refuses to provide him materials as to its genetic genealogy search and chooses the protracted litigation involved with a grand jury rather than a preliminary hearing. So once again, the state sped this up with the grand jury proceedings. We all knew that. Seems like everybody was on the same page with that. But in so doing and speeding up that timetable, they have to give the defense everything they're entitled to so that they can properly prep for this trial in October. And the defense thinks that includes genetic genealogy information that they're seeking, that the state is blocking. We know that. We've read lots of motions back and forth and arguments about whether or not they're going to turn this stuff over. It's also why the judge in a speedy trial case needs to make these decisions as quickly as possible. Yes, you're entitled to it, or no, you're not. It is particularly ridiculous that the state claims the public has some stake in forcing Mr. Kohberger to either abandon his constitutional right to defend himself or permit this case to carry on as indefinitely as the state wishes. So this is a common theme that most defense lawyers think, and I think that they're mostly right about it. The state wants to pressure you and do things to force you to waive your right to a speedy trial. And then they want to do what we see happen in so many other cases like Sarah Boone, like Lori Vallow or Daybell or whatever it may be. In these cases just continue on forever. Sometimes the state asks for a continuance. Sometimes the defense asks for a continuance. But either way, the state or the case continues on indefinitely. And that is always a big problem that the defense wants to avoid if they can. Sometimes the defense needs a delay. They need an extension of time. They need a continuance. And they have no choice but to waive speedy trial because of an expert, a witness is out of town, whatever it may be. But if you don't have to, then you shouldn't, especially in situations like this. Either the public wants its trial in October or it does not. The state's position on waiver of speedy trial is its own. If the public is to take any interest in this situation at all, it should be to wonder at the cavalier attitude the government has towards one of the fundamental rights secured to our citizens. So again, does the state want a speedy trial? Because if they do, then they should provide all the defense and everything that is necessary for due process, for a competent defense, and for a fair trial. They should produce all of that. And that doesn't mean we can't have disagreements between the lawyers, right? We can definitely have disagreements as to what is appropriate, what is discoverable, what is necessary, what's material. But if the state is going to delay the IGG, and then the judge ends up saying, you've got to turn it over. Well, now, judge, we've wasted another month. So we need another month of extension attributable to the state because they're not giving it to us. Grand jury stuff. They seem to fight back and forth, and then it seems like the defense got basically everything they wanted with the grand jury documents. That created a delay, and that is what's been added on to the back of speedy trial. We talked about a lot of this stuff with the alibi, with the grand jury proceedings, with the speedy trial rights, with the due process rights, Sixth Amendment rights, with the media stuff. Basically, the most important part of this process is to make sure we don't violate the rights of the accused, somebody who's presumed innocent. And we want to make sure and do everything we can to secure that. And forcing the state attorney to do their job and try the case in 6 months is not really that difficult of a balancing act. You have to do that. Make good decisions. Don't delay the case. I wish this was the case in every case, civil and criminal, but it's just not. There are so many delays in our justice system. And some people say delayed justice is no justice at all. And I agree with them to a certain extent, depending on the delay. So I hope the state and the defense can come to an agreement on the IGG, or the judge will make a ruling. And if they rule the state has to turn it over, they do it immediately. I mean, another option is the in-camera review of the IGG information. So then we're going to have to set that date, in-camera review. Then they're still going to have to argue what they get. Then the judge will still have to make a decision. And meanwhile, the defense has to wait to get their expert until they get this information. Because this information, maybe not wait completely, but this is going to have to be at least supplemental or additional information they give to their expert. So this is legitimately creating a delay. And if worst case scenario happens where they turn over some of the IGG family tree stuff and the defense says you didn't turn over all of it and they happen to be right, and a month goes by and then the state turns it over, the defense gives it to their expert and the defense tells the judge, the state just gave this to us. There's no way our defense expert now can prepare this stuff for a trial on October 2nd. If the state would have given it to us when we first asked 3 months ago, this would have been fine. Therefore, we can't have this trial. It's not a fair trial within the speedy trial period. Therefore, they've violated his speedy trial rights, dismissed the case. Or another partial waiver where we get a continuance, but it's not attributable to us. Just because you ask for a continuance does not mean it's attributable to you. Which is why I would say this 37-day grand jury document delay, the defense would argue is attributable to the state because of their delay, or powers outside their own that they couldn't get the grand jury transcripts and materials in time, and therefore it's attributable to neither side, but still not a waiver of speedy trial, meaning a delay attributable to the defense. So a lot of moving parts here, and the defense is right. Be careful, state. Be careful, prosecutors. When you go violating defendants' constitutional rights, as we saw in Lori Vallow Daybell, the judge pulled the death penalty off the table. And I think it's because of how some of this stuff was mishandled with her speedy trial rights. And you better believe that's going to be a huge part of the appeal. So let me know your thoughts. Let me know your questions in the comments. Thank you so much for joining me on this short Kohberger update. That's all I've got for this one. I'll see you on the next side. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.